The defense team for Luigi Mangione, the defendant captured on video murdering United Healthcare CEO Brian Thompson in cold blood, is now seeking sanctions against the prosecution, up to and including dismissal of the charges, because prosecutors allegedly drafted a fraudulent subpoena seeking a copy of Mangione's health records from Aetna. Now, before I get to the alleged improper subpoena, I'll mention this bizarre twist in the murder plot. Mangione wasn't even a customer of United Healthcare, but of Aetna. Apparently, the motive for targeting Brian Thompson was because United Healthcare was the largest health insurer, is the largest health insurer. And we know by now from myriad examples that these killers crave attention. They love it. He wanted maximum attention for his crime. Regarding the subpoena, Mangione's defense team asserts that prosecutors improperly compelled Aetna to produce confidential health records in violation of HIPAA. That's the health privacy law, but HIPAA doesn't prohibit disclosure. HIPAA only requires that certain procedures be followed. Now, the main safeguard against improper disclosure is notice to the defendant, but the defense often can be tricky where this is concerned. Often in a court case, the prosecution and defense usually work it out between them to send and accept service of documents by email because it's the fastest way to exchange documents, because it is a document subpoena we're talking about here, a subpoena duces tecum. And when I refer to exchange documents by email, I refer to uploading it to a secure server. That's often the method that's used now. But when being tricky, sometimes the defense will demand personal delivery of printed documents. They can justify that demand if there's a genuine issue about the authenticity of the documents. In most cases, that concern can be alleviated by showing the electronic PDF copy of the documents to the defendant, who can assert whether any of the documents were falsified. And although it seems Mangione is crazy, he's academically gifted and can certainly look through documents being presented by Aetna as his health records to determine if the records are not authentic. And also, Aetna has a sizable legal department. Aetna's attorneys turned over his records to the prosecution, so it's likely that Aetna's lawyers independently determined that the subpoena was valid. Now, maybe the judge in the case will determine it wasn't valid, but there was no way for Aetna to know in advance what the judge would decide. Aetna's attorneys had to make their own reasonable determination given the information available to Aetna at the time. Prosecutors say that Aetna inadvertently sent more documents than what the prosecution requested. This is very common in court cases. It just happens, especially when dealing with large companies. The lawyers try to act quickly in response to the subpoena, so they might use a database search or AI to determine which document should be produced. Now, here the prosecution determined that some of the documents they received were beyond the scope of the subpoena. They were given more documents than they asked for, essentially. And usually, if there's a sanction for this type of overproduction of documents, the judge will just say, well, the third party overproduced, so the prosecution has to delete those documents and can't make use of them. At this point, the defense could assert that the disclosure poisoned the case to such an extent that the entire case has to be dismissed. But the prosecution's response could be inevitable discovery or independent source. In other words, we would have discovered this information anyway through the normal course of investigation, or we can show an independent source for this information, aside from the production of documents by Aetna. And do I think that the judge in this case would even consider dismissing all charges against the defendant just because Aetna overproduced documents in response to a subpoena? No way. Dismissal of all charges would be a vastly disproportionate sanction, especially since Aetna made an independent determination and was represented by attorneys of its own choosing, who decided to overproduce, whether inadvertently or not. Now, if Mangione's defense lawyers want to file a case against Aetna, they can do so, and that's probably what Mangione should have done to begin with. File a case against his own health insurer if he had a problem with them, instead of murdering the CEO of the largest health insurer, who had nothing to do with his case or his health issues. The next hearing in this case isn't until December, although because of the document subpoena issue, there might be an earlier hearing. The judge has said that the trial will take place sometime in 2026. But whenever the trial occurs, I anticipate that the scene outside the courthouse will be a spectacle of craziness like we've never seen. Now, he may be legally insane indeed, because what he's done is just so vile and seeks to topple the pillars of a civilized society such that society, through its prosecution of him, will demand the maximum retribution, unless he can demonstrate the legal standard of insanity. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.